than 3 decades, where he has dealt with a number of important cases. He specializes in the field of GST, customs, central excise, service tax, and allied laws. Mr. Patil is heading an organization of advocates and consultants under the name called Senex Legal, and that organization specializes in all types of indirect taxes. Over and above his acumen in advocacy, Mr. Patil is a good orator and has delivered lectures on the subjects of his specializations in various professional institutes, trade associations, and etc. from time to time. The clientele of Senex includes central government, state governments, undertakings, public and private limited companies, partnerships, long list of it, and most important, spread all over India. Speaker, sir, it's a privilege for us to learn from your experience. Over to you. Please start the proceedings, sir.
Thank you very much, Mr. Seal. Good morning, everybody. I hope I am audible.
Yes, sir.
Yeah. Again, good morning, everybody. See, today I have been requested to address on time barring of GST refunds and some judgments which are there in central excise, service tax, customs also, whether they would have any relevance. So far as these topics are concerned, many and some of the topics which I am addressing have already been addressed partially by somebody else also. They have addressed nicely. And with this, there could be some overlapping at the very same issues and very same subjects. And I may not start with the slides which will straight away go to the point. My submission and suggestion would be, before coming into GST, what were the issues which were there and how the law has evolved? It would be ideal to peep in and look at the situation. IJ come to pre-GST era, that is up to 30th June 2017. Section 11B of Central Excise Act 1944 was providing a specific provision for refund. In that refund, initially up to 12/5/2000, the limitation was 6 months within which from a particular relevant date which is specified, refund was to have been claimed. Whether such refund pertain to short levy or non-levy, which subsequently has been held to be not payable. And corresponding certain notifications also were there. Even under section 11B, as relevant date certain were there, that is export of goods also. And there was also a situation of unjust enrichment, which section 11B was amended on 20th September 1991 retrospectively to bring in any refund and every refund arising out of under all circumstances would be subject to not only unjust enrichment and other criteria and conditions which have been specified therein. So far as export is concerned, in Central Excise Rules 2002, there was a provision like Rule 18. Under Rule 18, a person who is going to manufacture the goods and export was eligible and entitled for getting the inputs on payment of duty, and whatever the duty which is paid thereon would be claimed as refund. And likewise, the final products manufactured, when are exported, if any duty is paid thereon, such central excise duty was refundable under the name and style rebate under Rule 18. Then under Rule 18, some notifications were there. My purpose of explaining this Rule 18 or for that matter section 11T is that I am attempting to compare between GST provisions as are there from 1/7/2017 and whatever the provisions prior thereto, that is up to 30/6/2017. And under 18, I was referring to one notification by number 19 of 2004. It was a central excise notification, non-tariff notification dated 6/9/2004. This notification 19 of 2004 permitted procurement of inputs on payment of duty and export these goods on payment of duty. In a nutshell, 19 of 2004 permitted refund of duty paid on the goods exported, subject to following certain procedures. And another notification by number 19 21 of 2004 was issued. At the same date, under Rule 18 of Central Excise Rules 2002, which permitted procurement of inputs on payment of duty, and whatever the duty paid on such inputs which are used in the manufacture of the final products which are exported, that rebate was admissible. In a nutshell, under Section 11B, read with Rule 18, read with Notification 19 of 2004 and 21 of 2004, there was a provision for claiming refund of duty paid on the final products exported and refund of the duty paid on the inputs used in the manufacture of the goods exported. Now, let us compare these provisions with GST provisions. In GST, it is a continuous, unbroken chain of continuity of input tax credit is there. And that's a concept of manufacture has gone. Concept of supply has come as per the provisions contained under Section 7 of CGPI Act. Therefore, each person, irrespective of whether he is carrying out any manufacturing activity or otherwise, once he is making supply without carrying out any processes thereon, he is eligible and entitled for tax credit under Section 16, as long as those are used in or in the course of the furtherance of the business. Now, as you compare this with today in GST, the concept of zero-rated taxes has come. Concept of zero-rated taxes, we will have to go to Section 16 of the IGST Act. 16 of the IGST Act says, when supplies are made to 100% to a SEZ unit or SEZ developer, that will be treated as zero-rated supply. And likewise, any goods or services both are exported out of India, those also would be treated as zero-rated supplies. Then what inputs or input services used for making zero-rated supply, the corresponding input is admissible under Section 16 of CGPI. And here, as the goods are received from other person, and the recipient is required to take input tax credit if he wants to avoid the cascading effect. And the input, what goods which are purchased from the seller, that is selling or the selling registered person, whatever the tax, both CGST or IGST, or for that matter only IGST are so.
Excuse me, sir.
That,
excuse me, sir.
Please.
Excuse me, sir. I'm very sorry to interrupt, but your voice is lagging. Voice is lagging and breaking in between. So can you do one thing? Can you put off your video so that the voice may improve? Can you do that, sir?
1 second.
Because the voice is lagging. The voice is lagging.
Now I have put up stopped my video.
Yes, and sir, थोड़ा ऑडियो अगर जो भी आपका है लैपटॉप अगर आप थोड़ा पास में लेंगे तो शायद वॉइस क्वालिटी improve. Please help us that way. So because the voice is lagging and we are not getting a clear. So just try for a few more minutes and I think this should settle down. Please continue, sir.
Can you
please
hear
continue.
now?
Yeah,
am I audible now?
Yes, sir, you are audible. And yeah, please carry on now, sir.
Yeah, please.
Thank you so much, sir. Thank you so much.
Yeah, please.
Hello.
I was
Patil Sahab. Hello. Patil Sahab, this is Ishan. Can I just request you to briefly repeat what you said? Because most of us could not hear what was said in the first 10 minutes.
Hello.
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 Patil Sahab.
Hello. Yeah, tell me.
Can you please repeat what you said in the first 10 minutes? Because most of us could not hear what you were saying.
Okay, thank you very much. Thanks for prompting. Yeah, thank you very much. Yeah. I hope I'm audible now.
Yes, sir.
Yeah, please. Under prior to 1/7/2017, before advent of GST, provisions of central excise service tax were there. Under central excise, under Section 11B of Central Excise Act, wherever duty was not payable but paid, that amount of duty was refundable. There were also 7 dates till 12/5/2000. It was 6. I hope I am audible. Hello. Hello.
Yes, sir. Yes, sir. Much better now.
Yeah,
Much better now.
Yeah. Please. There were 11 dates under section 11B. Up to 12/5/2000, it was 6 months, and thereafter it was increased to 1 year, within which period from the relevant date, rebate or refund was to have been claimed. Then there were specific provisions pertaining to export. I was referring to Rule 18 of Central Excise Rules 2002, whereunder whatever the duty paid on inputs or whatever the duty paid on the final products which are exported, in the form and name of the rebate, refund was being given. For that, they had carved out certain notifications also. Those notifications I was referring to, first one was 19 of 2004. This 19 of 2004 permitted refund of duty paid on the goods exported, and such export was to have taken place within 6 months from the date of clearance from the factory, unlike in GST, which has been reduced to 3 months. Then another notification by number 21 of 2004 permitted procurement of inputs required for manufacture of the goods exported, and such rebate of duty paid on inputs was permissible, subject to following of certain procedure, which was known as Chapter 10 procedure, which was known as removal of goods at concession rate of duty for manufacture of goods, etc. Under this scenario, another rule was there, that is Rule 19. As I was referring to procuring inputs on payment of duty and claiming rebate or refund, and also exporting under rebate. Then another rule, that is Rule 19, permitted procurement of inputs without payment of duty under bond or under a letter of undertaking, and use them in the manufacture of the final product, and export them under bond or under LUT without payment of duty. And to give effect to this, notifications by number 42 of 2001 were issued. 42 of 2001 permitted export of final products without payment of duty under bond or under letter of undertaking. Likewise, 43 of 2001 notification, it was issued under Rule 19, permitting procurement of inputs without payment of duty under bond or under LUT. Then on export of goods, the bonds were discharged. Here I am attempting to say that both the streams are available. Now kindly come to GST era. In GST era, since there is a continuity of the admissibility and entitlement of input tax credit under Section 16 of CGST Act, the concept of manufacture has gone, and as and when any goods are received, irrespective of any activities carried on or otherwise, the input tax credit is admissible. And that's why when any goods are issued, then those goods as such, even if those are exported, ITC is admissible. Unlike in a central excise era, wherein we were permitted to get inputs, carry out certain processes. Here I am referring to notification number 40 of 2017 CTR or 41 of 2017 integrated tax, whereunder the registered person who is supplying the goods may supply on payment of IGST of 0.1%, and these goods on receipt by their merchant exporter has to account for, and goods come directly to the port of exportation. What I'm attempting to say is that in GST era, goods as such are permitted to be procured under notification 40 or 41 of 2017 CTR or IGST as the case may be, and export as such without subjecting to any process. Such concept has gone. Now, there was another rule like Rule 5 of St. Rules 2004, which permitted refund of duty paid on inputs or input services, Senate credit, and that Senate credit was permitted as refund under notification 27 of 2012 issued. Somewhat similar issue was also there under Rule 5B, wherein when services were chargeable to GST under reverse charge mechanism, and if the person who is paying is not able to utilize, then there was a provision for refund. Now, as I completed central excise, now I am just peeping in prior to 1/7/2017 in service tax era. In service tax, as you are aware of, from 1/7/2012, there was a rule by number Rule 6 capital A of service tax rules. According to Rule 6 capital A, export means 6 conditions were to have been satisfied. That is, provider of services situated in taxable territory, recipient of services situated outside India, then place of provision of services outside India, then the provider of service and recipient of services are not merely two establishments of a distinct persons as referred to in 65B44, or for that matter, the value for the service is received in convertible foreign exchange. And the last condition was, it was not specified in 66D, that is negative list. Subject to fulfillment of these 6 conditions, it was treated as export. Unlike this situation, if you can kindly come to the GST era, more particularly, I am referring to Rule 2(6) of IGST Act, which says that export of service means 5 conditions we have to satisfy. Condition number 1, supplier of services situated in India. Condition number 2, recipient of service is situated outside India. Condition number 3, place of provision of supply is outside India. Then fourth condition is that value payment for the service is received in convertible foreign exchange. Convertible foreign exchange. And fifth and last condition is that the supplier of service and the recipient of service are not merely establishment of distinct persons to Section 8 of IGST Act. If you compare this, what is export of services in GST era and what is export of services in 6A, you will find some difference, and that makes also further difference for discussing further. And so far as export of goods is concerned, it under clause 5 of section 2 of IGST Act, taking goods out of India to a place outside India would be treated as export of services. Now, again, going back to the service tax era, since I am discussing Rule 6A, there were some notification by number notification 39 of 2012, which permitted refund of service tax paid on inputs, refund of refund of central excise duty paid on inputs, refund of service tax paid on input services, which were used for export of services. That was notification 39 of 2012. Then likewise, another notification by number 41 of 2012 was there, that was permitting rebate of service tax paid on taxable services, which are used for export of goods. And with this background, now we are coming to GST era. And so far as GST era is concerned, in a sense, more particularly, they are referring to a situation wherein zero rated supplies under Section 16 of IGST Act. And Section 16 of IGST Act says what will be treated as zero rated supply. 1, export of goods or services outside India, or use of inputs or input services are for making this zero rated supplies. Then another is supply of goods or supply of services to SEZ developer or SEZ unit. Then one distinct difference which has been made under subsection 2 of section 16(2) is that the input tax credit of the inputs or input services paid is admissible even if these goods or services are exempt from payment of, even if those are wholly exempt or chargeable to nil rate of tax, still the refund of unutilized credit would be admissible. Only rider is 17(5), subsection 5 of section 17 of CGST Act, which blocks certain credits, and those credits subsection 3 of section 16 permits that you have an option either make zero rated supplies under bond or under letter of undertaking. Then whatever the corresponding input tax credit is there, that you claim as refund. This would be governed by section 54. Or in alternative, make zero rated supplies under bond or under LUT and claim IGST refund. And here the scenario again would be governed by section 54. With this background of central excise, of service tax, of marginally IGST angle, now we are going into the refunds under GST. With this background, possibly we would be able to understand better. Now, if we can kindly turn to second slide, since it is with, I think, Mr. Seal or Mr. Rinav. Hello.
Yes, sir.
I think slides you are controlling. You may have
Yeah, we are doing, sir. We are doing, sir. In a minute, we are doing, sir.
Yeah, please. Then shall I go on addressing further?
Yes, sir. You start. You continue addressing.
Yes, sir.
Yeah,
Yes,
yeah.
sir.
Please. See, section 54 permits any person who has paid GST, interest thereon, penalty, or any amount which was not payable, he can claim this amount as refund, and the limitation is 2 years from the relevant date. If you want, we can slide down if you permit us.
Sir, 2 minutes, sir. Yes, I'm doing it.
Yeah, please. And there is a proviso to subsection 1 of section 54, which says that if there is an unutilized credit in electronic credit cash ledger, now.
Yes, sir. This was the slide you expected, sir.
Yeah, this is a content we would be covering today. These are the things I am not reading. Kindly turn down to second slide. Yeah.
Okay, sir.
Yeah. Then I was referring to a situation of subsection 1 of section 54, which permits that any person claiming refund of any tax or interest, if any, such person can claim refund within that 2 years from the relevant date. There is a proviso also to that effect, which proviso says if there is any unutilized balance in electronic cash ledger, this unutilized credit can be claimed refund through return file under section 39. With this, I am attempting to say, so far as the refund of the unutilized balance of the cash, which is my amount, I have deposited in my account without any limitation whatsoever. As long as that balance is there, I would be able to claim refund in the return itself. Now, what is that 2 years and what is that relevant date we are referring to? That is governed by the explanation. And that explanation says, firstly, what is this refund? Whenever any expression refund is used in section 54, it is referring to tax paid on zero rated supply. Second, tax paid on input services used for making this zero rated supplies. Then it also refers to a situation of refund of tax on supply of goods which are regarded as deemed exports. And the last, that is fourth one, which is covered under refund, is refund of unutilized input tax credit in accordance with subsection 3 of section 54. Now, for computation of 2 years, relevant date would come into the picture. In that second slide, if you can kindly come to, please. Second slide, yeah. When the goods are exported, what would be the relevant date from which 2 years will start? As I was referring to, goods could be exported by sea or air, by ship or aircraft. Then that ship or aircraft, when it leaves India, would be the relevant date from which 2 years would be computed. Here would be a situation wherein shipping bill would be filed or bill of export in case of export by road would come into the picture, wherein there is an endorsement of the customs authorities to the effect that this ship or aircraft has left at a particular on a particular day. That will be the date which would be taken for the purpose of computation of 2 years. However, if the goods are exported by land to our neighboring countries like Bangladesh or so, then if the goods are going by land by a road carrier also, then when the goods pass the frontier would be the date from which 2 years would be computed. In case of export of goods by post, what is the date of dispatch of goods by post by the post office would be the relevant date for the purpose of computation of 2 years. Here we are talking of a situation of export of goods as well as inputs or input services used for export of goods, and that relevant date will be when the ship or the aircraft or the truck goes out of a frontier, when it is crosses, leaves India. And so far of post is concerned, date of dispatch of the goods. It does not cover supplies to SEZ unit or SEZ developer. Those would be governed by a provision which could be last in number, that is H, that is date of payment also. Yeah. Now kindly turn to second slide, please. Now we are also discussing deemed exports. What now you will put a question, what is deemed export? We would have to go to section 143. Under 143, government is empowered to declare that these are the supply of goods which would be treated and deemed as export. Now, in exercise of the powers conferred under section 147, I'm sorry, not 143, 147, a notification by number 48 of 2017 has been issued. According to 48 of 2017, supply of goods by a registered person against advance authorization is treated as one of the deemed export. Then second one is supply of capital goods by a registered person against EPCG authorization. Then third would be supply of goods by a registered person to 100% EOU. Fourth and last would be supply of goods by a bank or public sector undertaking of gold under customs notification 50 of 2017. These are the four categories of supplies which supply of goods are not going out of India, are going to certain specified categories of personnel, that is advance authorization holder who is procuring inputs without payment of import duties, or EPCG license holder, or for that matter 100% AU, or for that matter a public sector undertaking or bank supplying gold under notification 50 of 2017. These are deemed to be export, and that's why these are deemed export specified under section 147. With regard to supplies made which are treated as deemed export, the relevant date for computing 2 years would be 2 years, that is the return relating to such deemed export. What is the date on which we file return? It would be, that is supply of goods regarded as deemed export where the refund of tax paid is available in respect of goods. The date on which return relating to such deemed export is furnished. Means it is coming to the date of filing of return, and in that return these deemed exports have been mentioned. Now, if you can kindly turn to second slide, please. Now we are coming to export of services. I have exported services out of India, or I have used inputs or input services for making these services for export. In this scenario, whatever the taxes which are paid on the inputs or input services as well as on the services if I am claiming, then if I have already supplied the services, then the date of receipt of payment in convertible foreign exchange would be the relevant date for the purpose of computation of 2 years. And likewise, where the payment was received in advance prior to the date of issue, then date of issue of invoice would be relevant for the purpose of computation of 2 years. In a nutshell, if supply was made, payment was not received, and payment has been received in convertible foreign exchange. And when I'm saying convertible foreign exchange, I am conscious to say either receipt of convertible foreign exchange or in Indian rupees wherever Reserve Bank of India has permitted. And in case of receipt of advance, what is the date on which I issued invoice would be relevant for the purpose of computation of relevant date. If you can kindly turn to second slide, please. Second slide. Next slide. Now, a situation wherein, in the sense, when the question of refund comes, litigation may come in the picture. In case of litigation, and if the matter is taken to appellate authority, it could be first appellate authority, it could be GSTAT or so. In that case, if in an event of we getting a favorable judgment, the date of communication of such judgment would be relevant for the purpose of computation of 2 years. You would also find whether it is under section 1077 or for that matter section 112 for going in an appeal before tribunal. 107 section of CGST Act is for going in an appeal to first appellate authority, and 112 is for going in an appeal before GSTAT. And there we are required to make pre-deposits. These pre-deposits, when I have made, whether it is 10% or 20%, whatever the upper limit is there, over and above the admitted amount which I am depositing for pursuing my appeal before appellate authorities, I would be eligible and entitled for such pre-deposit in an event of I getting a favorable judgment in my favor, and the relevant date I have to claim within 2 years is date of communication of judgment. Now, if you can kindly go to next slide. Here it is talking of a situation of refund of accumulated credit. Accumulated credit could be on account of two areas. I would peep in for a moment subsection 3 of section 54. Subsection 3 of section 54 makes provisions that the registered person may claim refund of any unutilized input tax credit at the end of the tax period. This claim of refund of accumulated credit taken on the inputs or input services which I am not in a position to utilize under certain exigencies is subject to a rider contained in subsection 10 of section 54. Subsection 10 of section 54 says that if the registered person has defaulted in filing return, he has not filed return. It could be GSTR 3B or so. If he has not filed return, it goes without saying that he has not paid GST on the supplies made during that particular tax period. And likewise, second exigency could be certain dues are there. He is required to pay any tax, interest, penalty which he has not been stayed by the court or the tribunal or the first appellate authority by the specified date. In a scenario where a registered person has not filed return and has also not paid his past dues which had arisen under section 73 or under section 74, and that has not been stayed by the appellate authorities by the specified date, then proper officer has two options available. Option number one, withhold the refund until the said person has furnished the return or paid the tax dues, whether it is interest, penalty, or so. Another option available to the proper officer is deduct this amount of due, any tax or interest, and what is left over remaining, that much allowed would be payable. Maybe you may put a question that in the sense, as I go in an appeal, stay may not be granted. And likewise, another thought may come in our mind that GSTAT, what is tribunal, has not yet been constituted, and as and when it is constituted, then only I would be able to file an appeal against order passed by first appellate authority or order in revision. In this scenario, there is a specific provision which has been carved out in section 107.7, as well as I think 112.8 and 9 subsection, whereunder on the pre-deposit of the specified amount which is required for pursuing the appeal, it is deemed that the balance amount of dues have been stayed. In a nutshell, on going in an appeal, after making pre-deposit, the rider, what I was referring to with a force of subsection 10 of section 54 would not come in the picture. Now, I am going back again to subsection 3 of section 54, which lists down which are the exigencies under which a registered person is eligible and entitled for refund of unutilized input tax credit. First proviso says that refund of corresponding accumulated credit on inputs or input services is available when I am making zero rated supplies without payment of tax. I am going back to section 16.3 of IGST Act, and in that 16.3, A says that option, first option, preferred option, make supply of zero rated supplies under bond or unreality without payment of duty. In that case, corresponding input tax credit on the inputs or input services, you will be eligible for claiming under clause A of first proviso to subsection 3 of section 54. Then clause 2 of the same subsection, first proviso says that where the credit has been accumulated because of inverted tax structure, that is, rate of tax on the inputs is more than the rate of tax on the output. In that scenario, continuously there is unutilized credit, and that unutilized credit you can claim as refund under section 54.3, that is first proviso. Then another rider says that if these goods are subject to export duty, then needless to say that such refund of unutilized credit would not be admissible. Then second proviso says that if the person who has made this zero rated supply, or for that matter, in the sense there is an inverted tax structure, but he is claiming drawback in respect of central tax, he would not be eligible for refund of unutilized credit. Likewise, if he is claiming refund of the integrated tax paid on the supplies, then also he would not be eligible. Subject to subsection 3 of section 54, refund of unutilized credit would be admissible. Now we are coming back to the relevant date. I am referring to clause E to explanation, and which says that in case of refund of unutilized input tax credit under clause 2, what is clause 2? As I did refer to inverted tax structure. That is, rate of tax on the inputs is higher than the rate of tax on the output supplies. I repeat again. In case of refund of unutilized input tax credit under clause 2 of first proviso to subsection 3 of section 54, the due date for furnishing of return under section 39 for the period in which such claim for refund arises. Somebody's mind may think in a slight, you are coming, you are bringing in a due date of furnishing return. Due date of furnishing return for a particular month would be 20th of succeeding month. Then 20th of succeeding month onwards, 2 years is the period available. I am conscious that this clause E was substituted from 1 to 2019. For the period from 1/7/2017 to 31/1/2019, last date of the end of the financial year was a relevant date from which one could have claimed refund within 2 years. Maybe some questions may come on this. It is a unique situation. Means the period for computation of 2 years starting point has been curtailed. Now I am moving to second one. I hope I am audible, please. Hello. Hello. Hello, Mr. Renau, Mr. Seal.
Yes, sir. You're audible, sir.
Yeah,
Yes, sir, you are audible, sir. Very much.
I'm audible. Hello.
Yes, sir.
Yes, sir. Yes,
Please,
sir, you are
please,
audible.
please.
Yes, sir.
Please. Yeah. Thank you very much. Thanks a lot. Now, I was referring to section 60 of CGST Act. Section 60 of CGST Act says, like in central excise also, we had a provisions like Rule 7 of central excise rules, or for that matter, Rule 9B of central excise act, central excise rules 1944, wherein today also
I think your audience. Hello, Patil sir. Hello.
problem.
Yes, sir. Now you can speak.
Yeah, please. Yeah. Then a registered person who is unable to determine the rate of tax, or he is unable to determine the value under section 15 on which he is liable to pay GST, would make a request to the proper officer requesting for permitting him to undergo provisional assessment. And in this case, he will execute a bond or letter of undertaking. And such, maybe we can change to second slide. And in this scenario, when the request is accepted, subject to certain submission of certain documents, the provisional assessment would be finalized. If you can kindly turn to second slide also, please. Yeah. Then in that case, there is also a provision for extension for another 6 months by joint or additional commissioner, and commissioner maximum up to 2 years. Then when this preceding, when this finalization of provisional assessment would take place, then the date of adjustment on finalization next slide.
Yes, sir, the next slide is on.
In this case, where the tax is provided provisionally under this act, and the date of adjustment
Patil sir. Hello.
He might have lost connection, I guess.
Friends, just wait. There is some issues for the voice connection. Please bear with us. Generally, it doesn't happen, but today there is some problem. Please bear with us. We are sorting it out.
Hello.
Yes, sir. Yes, sir. You are audible, sir.
Yeah, please.
Yes.
I was now going to a second slide wherein the person who is claiming refund is other than supplier. In that case, data receipt of goods or services would be relevant for the purpose of computation of 2 years. Here, what are the exigencies which could be covered? Exigency number 1. In case of supplies to 100%, that is making deemed exports. Any supplies which are deemed as export, normally the recipient who is receiving the goods is primarily eligible for claiming refund. And in case supplier claims, then with a NOC to the effect that recipient has not taken input tax credit and he would not take, to that effect undertaking would be given, then supplier would be eligible for claiming refund. In case of claim of refund under section 54 and such refund is claimed by a person other than the supplier, then date of receipt of such goods or services would be relevant for the purpose of computation of 2 years. Since on the subject, let us also go to SEZ also. So far as SEZ unit or developer is concerned, it is a supplier alone who would be eligible and entitled for claiming refund. And the recipient would not be eligible. And in any case, in cases wherein a person who has received goods or services, who has borne the incidence of tax, would be eligible for claiming refund. Now the last one, in any other case, it is the date of payment of the tax would be relevant for the purpose of computation of limitation of 2 years. If we can kindly change to second slide. Yeah. With regard to supply of goods or services, in any of the exigencies listed in relevant date does not come. That's why this has been carved out. In case of supplies to SEZ unit or SEZ developers, which is treated as zero rated supply under section 16(1)(b), then the date of payment of tax that is would be relevant, and that date of payment of tax would normally be the date on which the return is filed, that is 20th of succeeding month. Needless to say that with regard to goods which are supplied to SEZ unit or developer, the designated officer in charge of the SEZ unit or developer would endorse on the bill of supply, which is required to be prepared, to the effect that these goods have been received in SEZ and these goods are meant and would be used for authorized operation. And this endorsement would be required for claiming refund under Rule 89 of CGST rules. With regard to the supply of services to SEZ unit or developer, similar undertaking would be required, And needless to say that there should be a self-declaration to the effect that a CZ unit supplies a developer supplies made to them is not the tax paid has not been passed on. Then if you can kindly turn slide down. Next slide, please. Under subsection 2 of section 54, a special category has been carved out. Those are supplies made to specialized agencies like United Nations Organization or multi-financial institution or organization notified under United Nations Privileges and Immunities Act 1947, or supplies made to consulate, or supplies made to embassies of foreign countries. Refund by them, they are the recipient, has to be made within 6 months from the last day of the quarter in which such supply was received. In a nutshell, in the quarter in which such supplies have been received by these specialized agencies can be claimed within 6 months from the last date of the quarter in which such supply was received. As I did refer to initially only, in case of refund of balance in electronic, registered person is maintaining two ledgers. One is electronic credit ledger. Electronic credit ledger, he will go on taking input tax credit under section 16, read with section 49(6) and read with section 43 also on the whatever the receipts which are made and on which tax has been paid, subject to a condition that the same have been uploaded by the supplier under GSTR 1. If anything is not uploaded, then upper limit of 10% which have not been uploaded permission is there, that is under rule 36(4). That is that apart. And another register he is maintaining is that if the amount of credit which he needs for payment of GST on output supplies is less and he needs to deposit in cash, then he maintains electronic cash ledger in which he will go on depositing. And this electronic cash ledger, whatever the balance is there, and that balance is lying, he may not need because he has now sufficient balance in electronic credit ledger, then this will be lying only. It is like a personal ledger account which we are calling as PLA in Central Excise era. It would be like your passbook. And this balance which is there in electronic cash ledger, under proviso to subsection 1 of section 54, you can claim this refund through the return filed under section 39. Return could be GSTR 3 or GSTR 3B or GSTR 4 so far as composition levy, or for that matter GSTR 7 also. And I'm saying that for claiming such refund, there is no limitation available and they can claim as and when he wants to claim through the return furnished by him under section 39. If you can turn to second slide. Now, interesting issue would arise. There is a provision like section 677 in CGST Act. Section 77 makes a specific provision to the effect that there is a dispute with regards to place of supply. A registered person who has paid central tax or state tax, treating that as intrastate supply, subsequently during the course of audit or otherwise has been held to be a interstate supply, means he was to have paid integrated tax instead of paying central tax and state stroke union territory tax. Then in that scenario, he has to claim this refund and adjust. One school of thought is, where is the reference of this refund under section 77? Pausing for a moment here just to complete the circuit. In IGST Act, there is a section by number section 19, identical, similar to section 77. In case of dispute of place of supply, if it is held to be subsequently interest rate supply as against payment treating as interest rate supply or vice versa, then he would be liable to pay the correct tax, whether it is integrated tax or otherwise, and claim the refund of the tax earlier paid is a situation. Now, as I was coming to, I am of the opinion, strictly going by the provisions of section 54, limitation of 2 years could apply. If you refer to any one of the exigencies as I refer to in relevant date A to H, it doesn't fit into, it may fit into H only, that is the date of payment of tax. And if you go by date of payment of tax, my friends, I will pay on a particular day, treating that as interest rate. Subsequently, it is held to be interest rate. In that scenario, by that time audit points out, or by that time I realize, or by that time some judgment comes in somebody else's case, limitation of 2 years for claiming refund would have expired. Then would government want me to pay as other tax instead of interest rate tax, and forgo the amount what I have paid because under section 54 2 years has elapsed? Or is it a case that I should dispute? We are concerned about and worried about that, and we are attempting to find anyway. We could find one FAQ 87, which is dated, issued in December 2018, which says that there is no time limit for claiming such refund of disputed amount paid under section 77 of CGST Act or under section 19 of IGST Act. But although this FAQ is helping us and we are interpreting no time limit is available, I'm not finding any provision in section 54. If I may, for my benefit, take to your kind attention to subsection 8 of section 54, which lists down 6 exigencies to which doctrine of unjust enrichment is not applicable. One, it says it is having overriding effect, notwithstanding anything contained in subsection 5. Subsection 5 is a subsection which says that whatever the refund which is payable initially would be transferred to Consumer Welfare Fund unless it is proved that the incidence of tax has not been passed on to any other person. The refundable amount shall, instead of being credited to fund, be paid to the applicant if such amount is relatable to one, that is A, refund of tax paid on export of other services or both, or inputs or input services used for making such supply. If any tax is paid on the goods or services which are exported, or tax paid on the inputs or input services used for making this due supply to the extent of export of goods or services, unjust enrichment is not applicable. Then as you go second, refund of tax paid on goods or services, on inputs or input services, making such this thing, that is first one. Then refund of unutilized input tax credit under subsection 3. If there is a unutilized credit on inputs or input services which I am eligible for refund under subsection 3 of section 54, to that also unjust enrichment would not apply. Then third exigency is, I have received an amount of tax in advance, but I could not make that supply. Similar provision was there in Finance Act 1994, that is service tax also. Then I have not made supply either fully or partially. I also not raised invoice, and I have issued refund voucher. To this also unjust enrichment would not be applicable. Now the fourth one with which we are concerned is refund of tax paid in pursuance of section 77. That is dispute on POS. To that also unjust enrichment is not applicable. In a nutshell, when for the purpose of making unjust enrichment not applicable, under section 54(8)(d), section 77 refund has been mentioned. That does mean one school of thought that limitation of 2 years would be applicable, and department may harp upon a situation that you should have claimed refund within 2 years. By the time audit party comes, 2 years would be over. There could be a litigation on the issue. That's why we have written this is not free from doubt. And department may claim that would be governed by clause H, which says that in any other case, the date of payment of tax. If you can kindly change to next slide. Now, as a foreign passenger comes to India, he is going back to returning to his country. I am referring to a situation of refund of tax paid on goods supplied to international tourists in India and carried abroad at the time of their departure from India. Retail outlets are there which are up much beyond the departure area in international airports. That is beyond immigration counters. Then such retail outlet is supplying goods to international passenger, international tourist by issue of tax invoice. There is a corresponding input tax invoice issued by a registered person in favor of this retail outlet, giving cross reference of GSTIN and other details. And those goods which have been issued on payment of GST are being sold to international tourists by retail outlet. Then whatever the tax paid thereon, such retail outlet can claim refund on the end of the month or quarter in which such supplies are made. Although it has not been specifically carved out, this is the provision which has been made in section 15 of IGST Act and section 15 of IGST Act and corresponding rules made thereunder. If you can kindly turn to second slide.
Yes,
Now
sir.
I'm yep.
Okay.
Hello.
Yes, sir. You can continue. You can
Yeah,
continue,
please,
sir.
please. Now, two options I'll give. Whatever I have explained relating to relevant date and limitation, questions can be discussed. Or in alternative, I will complete the judgments. I'll complete the judgments. Under central excise era, with regard to export of services, there existed a dispute. Department was claiming that provisions of section 11B would apply. What is the date on which export has taken place? What is the date you received the value for the service exported, that is in convertible foreign exchange, would be the date, and that's why that whatever the refund which you are claiming is barred by limitation. They were referring to section 11B, rule 5 of Unjust rules, and notification 27 of 2012 also. Rule 5 subsequently was substituted. Then because of the divergent views on the issue, the matter was referred to larger bench in the case of Span Import Act. And the argument advanced on behalf of the trade where there is no exigency in which it can be fitted, and that's why it should be the quarter in which convertible foreign exchange has been issued, that is FIRC, and that would be the relevant date. Thus, in the case of spawn info tax, larger bench held that relevant date for claiming a refund of unutilized enrichment credit in respect of export of services would be the end of the quarter in which FIRC is received, and wherein they specifically carved out, they specifically held that Rule 5 of enrichment credit rules, when makes Section 11B applicable to export of service, provisions of 11B cannot be ignored. But however, since this exigency has not been specifically carved out, it would be export of services completed only on receipt of the consideration in convertible foreign exchange as per service tax rules and successor so and so. That's why the date, the quarter in which the convertible foreign exchange has been issued would be relevant for the purpose of computation of limitation what was prescribed under Section 11B. Now, with regard to this specifically has been taken care in the Section 54 only, and Section 54 in the relevant date only, they specifically says that in case of export of services out of India, they specifically says that receipt of payment of convertible foreign exchange where the supply of services had already been completed, or issue of invoice if the payment was received in advance, that is carved out in clause C of relevant date in Section 54 answer. That's why the same judgment indirectly has been given a legal shape. Now, if we can slide down, yeah. Hello.
Sir, is that okay, or should I slide down more?
No, it's okay. I'm not in a position to see here. That yeah, okay. Slide up, one more up, one up. Yeah.
Is that okay?
It is okay now. It is okay.
Okay.
Rather, I wanted to discuss. There is a notification by number 5 of 2017 clause C, which was amended by notification 20 of 2018, wherein the lapsing provision was brought from 1/8/2018. I am referring to the Gujarat High Court judgment in the case of Shabnam Petrofields. In that, the issue was with regard to certain textile items, whatever the accumulated credit can be utilized for the supplies made till 31/7/2018 and balance would lapse. That amending notification 20 of 2018 was questioned before the Honorable Gujarat High Court. Then Honorable Gujarat High Court is holding that where is the corresponding provision in the Act? When there is no provision under Section 54(3), that this notification cannot override the provisions which are there in Section 54, and it was held that the said proviso bringing in a provision for lapsing is expressly invalid, and that was struck down. I was just wanting to bring to the notice of our friends. Yeah, if you can slide down next, please. Now, I did say various exigencies, and various exigencies wherein limitation would come to the picture. Now, there are some exigencies which possibly may not have been covered. That is a case where I may refer to Rule 96B, which has been inserted subsequently, which says that I exported goods and I did not receive value for the goods within the time prescribed under FEMA or any extended period. Then as per Rule 96B, I am required to pay back the amount of integrated tax or any benefit which accrued to me to the government along with the interest at the rate of 18% under subsection 1 of section 50. In the meantime, however, if this requirement of receipt of value of goods is written off by RBI, then recovery would not be there. However, under sub rule 2, if I receive the said amount for the value of the export of goods in future, then I can claim back within 1 month of the receipt of the amount in convertible foreign exchange or Indian rupees wherever it is permitted. In a nutshell, Rule 96B requires me to pay back the amount of the benefit of refund I got if the value for the service in convertible foreign exchange has not been received by me within the stipulated period specified in FEMA or such extended period along with interest. And if this is written off, question of recovery would not come into the picture. And after paying back to the government, this amount is received by convertible foreign exchange. Then I should intimate within 1 month and reclaim that amount. I am attempting to say in between that, the limitation, what is there, would not be applicable. That is the period which is mentioned. And it is 3 months from the date of receipt, not 1 month. I just said this thing. Now, another mechanism I am referring to, it is not truly refund in cash or so. Under subsection 1 of section 34, supplier who is making supplies may issue credit note. And when the issue of credit note would come into the picture, there could be a case wherein I have paid tax on a value more than the value on which I should have paid. Second situation, I had made supply of goods which have been returned. Third situation, these supplies have been deficient either in terms of quality or otherwise. In this scenario, supplier of the supplies is obliged to issue a debit note. I am not referring to commercial debit note in accounting terminology. I am referring to issuance of debit note under subsection 1 of section 34. And this debit note has to be accounted in the return in the month in which it has been issued. Which makes me to recall the provisions like section 15(3)(b), wherein issuance of providing a discount subsequent to supply, subject to obviously two conditions are there. Linkage has to be established with the invoices under which initial supply had taken place, and the recipient reverses the input tax credit if he has taken. Such exigency and other exigencies also. Now you would put a question in the sense, what is the outer time limit for issuance of such credit note? It would be outer time limit would be the date of furnishing of return for the month of September next year, or date of furnishing of annual return under section 44, which normally is 31st December, whichever is earlier. By doing that, section 43 also would come into the picture, that is matching, reversal and reclaim of reduction of output tax liability. It is getting adjusted, the output tax liability, subject to section 34(1), 34(2), section 43, and reflecting in the returns for the month in which this credit note was issued. With this, after giving effect of this credit note, output tax liability is reduced to the extent of credit. Means this could be a situation of refund through adjustment, that is reduction of output tax liability. This was another exigency I had left. Then one more exigency is, as you are fully Section 16 stipulates 4 conditions for taking input, for availing input tax credit. Condition number 1, he is in possession of invoice or debit note and other documents which are prescribed. Then secondly, he has received the supplies. Third is, value for the what tax which has been shown in the tax invoice has actually been paid by the supplier. Fourth is, he has furnished return under section 39. And there I come to second and third proviso to section 16(2), which says that if the payment for the value of supply along with the tax payable paid thereon, which has been taken credit by the recipient by me, has not been made to the supplier, if the value of the supply along with tax thereon, if it is not made within 180 days from the date of invoice, then the recipient input tax availer is required to pay back that much input tax credit by adding to his output tax liability. Then Rule 37 also would come into the picture. Rule 37 read with section 16(2) second and third proviso says, to some cases this would not be applicable. That would be 1. The activities or the supplies which are referred to are the supplies which are specified in Schedule 1 to CGST Act, wherein without consideration also it will be treated as supply under section 7(1)(c). Then second exigency is, in case there is a contractual obligation on the part of the supplier to incur certain expenditure on account of certain activities, but which has been incurred by the recipient. Under section 15(2)(b) of CGST Act, this value of the cost which has been incurred by the recipient has to be added to the value on which GST is payable by the registered supplier. Here also question of payment of consideration would not come into the picture. That's why the restriction of payment within 180 days would not come. But with regard to other exigencies, wherein I am required to pay, I did not make payment, I reverse the credit by adding to my output tax liability. Subsequently, I am making payment of this amount along with tax payable there. In that scenario, after making such payment, you would be eligible for reclaiming of such input tax credit without limitation. These were the exigencies I thought. Now I am coming to whether limitation of 2 years or whatever the limitations I specified in other cases could be condoned, delayed or not. Various judgments are there. And these judgments, sum and summary of all these judgments is that courts are barred for extending the limitation of 1 year under central excise law or service tax to any period. One has to claim refund within the statutorily prescribed limitation of 1 year. This is a judgment in the case of Porcelain Electrical Manufacturing Company by the Honorable Supreme Court. In that case, Porcelain Electric Manufacturing Company were manufacturing various components of porcelain, and those were cleared on payment of central excise duty. And it was held in the another case, that is English Electric Company, by the Madras High Court that central excise duty was not payable on these porcelain components, and which judgment was upheld by the Supreme Court. That's how this porcelain electric manufacturing company filed a refund claim after the normal period which was prescribed under Section 11B. Wherein Honorable Supreme Court held all refunds are governed by the limitation under statute.
Time limit prescribed under statute only and only is applicable, and not even the 3 years
limitation period which has been prescribed in General Limitation Act would apply. I'm sorry. Then another judgment of Supreme Court I am referring to at the date of 9/10/1987 in the case of
Patil sir, can you come? Patil sir, excuse me, can you come near the mic or the computer speaker, please?
yeah, please.
The voice is very weak.
Hello. Yeah.
हाँ sir, this is
Yeah,
better. This is
Yeah,
better,
yeah.
sir. ये
Please.
आप ये distance पे ही रहिए.
Yeah. Now, I was referring to a judgment of Honorable Supreme Court dated 9/10/1987 in the case of Doba Cooperative Sugar Mills, where under initial refund, initially demands were confirmed by original authority as well as appellate authority, and tribunal at last held that this duty was not payable. That's how Doba filed refund claims. Then Honorable Supreme Court, while analyzing, they analyzed both the provisions, that is demand provisions under Section 11A and refund provision under Section 11B. And they put a question, if there would have been a demand, then obviously limitation prescribed for recovery under Section 11A would come into the picture. Contra situation of claiming refund under Section 11B also would be governed by the limitation prescribed under Section 11B. And it was held by the Honorable Supreme Court on 9/10/1987 that departmental authorities are bound by limitation, and even civil courts can initiate proceedings beyond this period. This is the rider I'm deliberately telling. In this judgment of 9/10/1987, Honorable Supreme Court, 2 judges held that civil courts may have powers, which subsequently goes out. Then in the case of Kirloskar, I am referring to second Supreme Court judgment in the case of Kirloskar Pneumatic Company dated 6/5/1996, wherein Honorable Bombay High Court held that in case of refund, customs authorities can ignore, and in the sense it is procedural. Which judgment of the Honorable Bombay High Court was challenged before Honorable Supreme Court, and Honorable Supreme Court is holding High Court cannot direct the customs authority, Section 27 of Customs Act. And wherever writ petitions are filed for effectuating Article 226 and 227, they should refer to the time limit prescribed in the provisions, and they cannot override them. And it should be consistent. And for doing that, not only the Bombay High Court judgment was set aside, but also invoked Doba and Mills India. Now, second judgment, which before I coming to Anam, I may refer to other judgments. The matter was also gone to Gujarat High Court.
in the case of Indian Oil Corporation. In the case of Indian Oil Corporation,
Sir, your voice is very loud. Can you please adjust your mic or the mouth, please, sir? It's blasting, sir. Can you please control it from your side? Hello.
Now we can. Now it is okay now. Hello, it is
Hello.
okay now.
It is okay, sir. Can you
Hello.
come a little closer to the mouthpiece or wherever is the mic, sir?
Okay.
You are clear now, but the voice is a little weak. Can you just come closer or within the range, please?
Yeah. Please. I'm coming. Yeah. Now it should be okay.
No, sir. No, sir. Your voice is still weak. Can you come to the mic? Hello.
If you permit me, adjust in the laptop, that voice adjustment.
Hello, Patil sir. Can you hear me?
Yeah, I can hear you.
Sir, your voice is very weak, sir. Your voice is very weak, small. It is clear, but it is very, very weak. Can you just improve your mic from your side?
Now it is okay.
Sir, the sound is very, very low. Can you take, if you are on your headphones, can you take the...
1 second.
Yeah, please, sir.
Would it be okay now?
Sir, still the
A
voice
bit louder,
is...
sir. A bit louder.
Can make it a bit louder, sir.
Now? Hello?
Hello, sir.
Yeah. Now?
Sir, the voice is very, very, very low, sir. We can't hear you properly.
Now, if you can permit me, because you have stopped me from increasing from laptop. You have control, no, that.
No, sir.
Right?
No.
If you permit me from adjusting in this laptop.
You can do anything from your laptop.
No, it is not happening because maybe. Manage partition. Only 1 second, please. Yeah.
Yes, sir.
Yeah, please.
I think sir is checking. Sir is checking from his side.
Hello.
Yes, sir.
Would it be okay now?
Can you be a bit louder?
Louder, you say?
Yes.
माइक पास रखना पड़ेगा सर को.
ना पास ही रखा है. Hello. Yeah, I'll be little louder. Let me see if I can.
Yes, sir.
Yeah, I was referring to a Gujarat High Court judgment. I hope.
Yes, sir. Continue.
Gujarat High Court judgment in the case of Indian Oil Corporation, wherein Indian Oil Corporation were supplying aviation turbine fuel to aircraft and foreign run. Supplies to aircraft and foreign run are deemed as exports. But by mistake, IOCL supplied on payment of central excise duty on ATF to aircraft and foreign run. Subsequently, on realizing, they filed refund claim under section 11B. That refund, since was rejected as time-barred, the matter was taken to Gujarat High Court. Honorable Gujarat High Court held that the limitation prescribed under section 11B necessarily has to be invoked for examining and allowing the refund claim. Claim was filed in March 2017 pertaining to the supplies made in April and October 2005. It was held that it is barred by limitation, and they invoked the various judgments as I referred to. Then matter also had come up before larger bench at tribunal in the case of Veer Oasis, wherein the issue was whenever
Any supply of service related to agriculture, there was an exemption under notification 13 of 2003.
And these services were rendered by a overseas party for export of agricultural produce from India. And this commission paid was department claimed that it is liable to the service tax under business auxiliary service. And accordingly, the Indian party paid under reverse charge mechanism under section 68(2) service tax. Subsequently, when he realized that there is a notification by number 13 of 2003 exempting such business auxiliary service pertaining to agricultural produce, he claimed Veer Overseas claim refund. Then refund was rejected on the ground that it is barred by limitation, and since it was not filed within the stipulated period of 1 year from the relevant date, and matter because of the divergent views was referred to larger bench. Larger bench had comprised 3 members. By majority, that is president and other technical member, it was held that statutory time limit cannot be extended by any authorities whatsoever, whether it is paid under mistake of law or otherwise. Single member in minority held that when it is an unlawful levy, government has no right to retain that amount. And that's why refund has to be given. Anyway, by majority, it was held that limitation prescribed under the provisions of law would apply. Now, I am coming to a judgment which might have been discussed by one or the other speaker. I hope I am audible.
Yes, sir. Perfect. Perfect.
Yeah, please. A 9-judge judgment of the Honorable Supreme Court in the case of Mafatlal Industries. This is a judgment dated 9/12/1996. This judgment and issue arose because of the amendment to section 11B, bringing in the doctrine of unjust enrichment in the section 11B itself on 20th September 1991, which amendment was given retrospective effect, that is from the day from which section 11B was brought on scheduled book. Although I may not remember when it was on, it may be somewhere on 1/19/1959 or so. Then various issues arose before the constitution, that is 9-judge bench judgment of Honorable Supreme Court. And wherein non-judge bench Supreme Court by majority has held that all claims of refund, irrespective of the circumstances under which this has been claimed, are governed by section 11B or section 27, 11B of Central Excise Act, section 27 of Customs Act, except where the levy is held to be unconstitutional. And all refunds arising under all circumstances necessarily have to be subject to the test of unjust enrichment as specified in subsection 2 of section 11B. And it was also held that the amendment which has been made on 20th September 1991 retrospectively is valid and constitutional. However, in case of those parties who had filed writ petition directly before High Court and which got merged with Mafatlal, Supreme Court gave a liberty. Okay, now you can file this claim within 60 days from the date of judgment of in Mafatlal, that is 19/12/1996. Then another issue arose whether the pending refund applications would be subjected to unjust enrichment. Because this law came from 20th September 1991, so far as unjust enrichment is concerned. And it was held that all pending applications, wherever they are pending, would be subject to not only unjust enrichment and all the provisions which are stipulated in section 11B. However, another issue arose. Okay, somebody claimed refund, he has got the refund, and that order has not been challenged by the department or otherwise. Then Honorable Supreme Court held, in cases where refund has already been sanctioned and granted by passing a order with due process of law, and those orders have not been challenged, then those cannot be reopened. Recovery proceedings cannot be initiated. Then one more question arose before the Honorable Supreme Court. Okay, if the department files an application or appeal before appropriate authority with an application for condonation of delay, what would happen? Then Supreme Court held, subject to condonation of delay, if the delay is condoned, again they will get revived and provisions of amended section 11B would apply. Even in cases, another issue arose, in cases where the courts or the appellate authorities have held that refund is admissible, and those refund after having held admissible by the higher courts would be subject to again unjust enrichment was a law which was held. And it was further held that even civil courts are not allowed or barred from extending limitation. Then another issue was, okay, this is section 72 of Indian Contract Act will invoke. Supreme Court comprising 9-judge judgment held that no, even section 72 cannot be invoked. And if anybody has approached through writ, and writ order should be in consistence with the provisions of section 11B. Only so far as levies which have been held constitutional, court may entertain. And it was also held that buyer is eligible. With regard to job work where sale is not taking place, and there it may not be applicable, and even 11D also would not be applicable. In spite of this judgment running into 247 pages is concerned, again some issues arose, and that's how the last judgment in the case of Assistant Commissioner of Customs Excise in Unum Electric came. And Unum Electric, they framed 7 questions, and those 7 questions were answered in Unum. One was whether prescribed under Central Excise Law or Customs Act cannot be extended by court. In Unum Supreme Court, 2 judges only, that judgment is dated 28/1/1997, held that even 3 years which courts are also not permitted, and if any court has extended, shall I read these questions and answer? This is very important, if you kindly permit.
Yes,
I'm
sir.
reading.
Yes, sir. Yes, sir. Please do that.
Yeah, please. I'm sorry. Yeah, Now, in the sense, I am referring to Unum, which is a later judgment, although it is 2-member judgment, which is interpreting the Constitution Bench judgment of 9-member, and they are framed questions and answers. Question number 1. Where refund application was filed by manufacturer / purchaser beyond the statutory time limit of section 11B(27). Clarification. Such petitions must be held to be untenable in law, regardless of any direction to the contrary contained in the order in any appeal, suit, or writ petition. Statutory time limit not extendable by any authority or court, even in case of illegal levy. Second question. Where refund application was filed within the statutory time limit, but a writ petition, suit, or appeal arising therefrom is pending or is now filed, or where such writ petition has been allowed and an appeal filed by revenue is pending. Then clarification. Manufacturer / purchaser shall be entitled to withdraw the said writ petition, suit, or an appeal arising therefrom, and file an appeal before the appropriate appellate authority within 60 days from the date of this order. This order is Unum's order dated 28/1/1997. Then third question. Where a writ petition or suit claiming refund was filed directly in High Court / Civil Court, that is directly, only one second. I am reading question 3. Where a writ petition or suit claiming refund was filed directly in High Court / Civil Court, that is without filing a refund application before statutory authority, but within the statutory time limit under section 11B or 27, or where such writ petition has been allowed and an appeal filed by revenue is pending. Answer. petitioner stroke plaintiff shall be entitled to withdraw such writ petition, suit, or any appeal arising therefrom and prefer a refund claim under section 11B stroke 27 section 27 within 60 days from the date of this order, that is 28/1/1997. 4. Above rules not to apply in case of claim for refund of duty levied and recovered under an unconstitutional provision. In such cases, period of limitation shall be as laid down in Mafatla 9 Judge Bench judgment, bar of unjust amendment applicable even in such cases. 5. Where a person fails in his challenge to constitutionality of a statutory provision. Answer. Such person cannot take advantage of the decision of the case of another person striking down the said provision, as explained in Mafatlal Industries 9 Judge Bench judgment. This rule is evolved
particularly in the context of central excise to custom and has to be optimal. Not a refund application or an appeal is prepared under an
Excuse me, Patil sir, there is a problem. The voice is not clear. Can you just again rearrange your mic, please, sir?
Okay. Now it is okay
Yes, sir.
to some extent. Marginally.
Sir, your voice could be a little louder, please, sir.
Okay, I can. In a nutshell, I need not have to read now left over to this thing. Anam examined, analyzed the 9 Judge Bench judgment of the Honorable Supreme Court and held that the limitation.
Sir, could the voice be a little louder, sir?
Okay.
Hello. Yeah, hello, sir. The voice could be a little louder.
Can you hear me?
Hello.
Yes, sir. Yes, sir. Now it is fine.
Hello.
Yes, sir.
Yes, sir, you can continue now.
No, इधर से नहीं हो रहा है.
Hello.
Yes, sir.
Would it be little better now?
A bit louder if possible, sir.
Okay. You are louder than me. I am not louder possibly. I don't know what is wrong with you. Yeah. See, in the case of Anam, Honorable Supreme Court analyzed from various angles, and summary of that judgment is not only unjust enrichment would be applicable to all refunds arising out of
all the circumstances are exempted from
Sir, your mic.
what is prescribed in nutshell.
Excuse me, sir. Excuse me, Patil sir. Again, your voice is a bit blurred, sir. Can you just improve upon your the mouthpiece, sir? It is again cracking.
Hello. Now. Hello.
Yes, sir.
Can you hear now? Am I audible?
Yes, sir. Yeah, it is better, but sir, please try to be a little louder. Otherwise, please continue, sir.
Okay. I think better I will be louder only because since that slide you are changing, I am not in a position to adjust from laptop. In any case, we are at fag end only, even judgments also. Yeah. I hope I'll try my best, whatever the best I can. Honorable Supreme Court, in the case of Mafatlal Industries, 9 Judge Bench judgment, as analyzed by Supreme Court in Anam Electric, held that pertaining to limitation, refund claim filed before the departmental authorities necessarily has to be governed by the limitation prescribed under section 11B or section 27 of
and even genuine
limitation of 3 years is not available, even if such levy is held to be illegal or unlawful. It further held that even courts are barred from extending time limit prescribed under Central Excise or Customs Act or so. Now, some more issues would arise. I hope at least I am audible little, whatever the best I can.
Yes, sir. Yes, sir.
Hello?
Now it is going perfect, sir.
Hello.
Yes, sir. Now
Yeah.
you are quite audible,
Yeah,
sir.
please.
Please go on. Please continue.
Yeah. Somewhere some problem could be there. Now I am coming to a situation wherein I did not make a proper application for refund. At this point of time, I would have to take the kind attention of my friends to subsection 7 of section 54, which says order has to be passed within 60 days from the date of receipt of application. Then sub rule 2 of rule 90 says an application has to be filed under RFD 1 and an acknowledgement to that would be issued under RFD 2. So far as the application for refund of my unutilized credit is concerned, RFD 02 would be issued, that is acknowledgement. Then within 60 days from the date of such acknowledgement, the fate of that refund claim has to be decided. However, with regard to other applications for refund of others other than refund of unutilized credit in my electronic cash ledger, the same would be forwarded to a proper officer who within 15 days has to scrutinize the completeness within 15 days, and completeness means with regard to if it is supplied to EOU, who would be claiming, with regard to supplies to SEZ unit or developer, whether those have been admitted and used for the purpose, with regard to an unjust enrichment, whether certificate has been issued. If they're less than 2 lakhs, then self-declaration to the effect that instance of tax has not been paid. If it is more than 2 lakhs, in the certificate from a chartered or cost accountant to the effect that incidence of tax has not been passed on, etc., etc. Then that proper officer will scrutinize within 15 days with regard to the completeness. Then only acknowledgement in RFD 02 would be issued on common portal. In such cases, from the date of acknowledgement, within 60 days, refund would be processed and it has to be decided. And within 60 days, if it is not paid, then interest at the rate of 6% I would be entitled for. But in case of deficiencies in the application for refund which I have filed, then a deficiency memo under RFD 03 would be issued and a fresh application after rectification of such deficiency has to be filed. Now, in this scenario, what I'm attempting to say is that under section 11B of Central Excises Act, refund application was filed. If those were any deficiencies, those deficiencies would be cured by a subsequent correspondence. And the date of initial filing of the next slide, if I change, date of filing of the refund application initially was taken to be the date for claiming that the refund application was filed in time. Second slide, if you can kindly change. Now, in this scenario, my point is that 60 days from the date of acknowledgement is only for the purpose of payment of interest. But I am more concerned about the limitation. If I write a simple letter that this is a situation and in a circumstance of it being decided in my favor, I would be eligible for entitled for refund, then whether such letter could be treated as the date of taking of refund and limitation, barring limitation of 2 years or any other limitation, would not be applicable is a proposition which I am making. In this connection, possibly I may refer to some of the judgments which are under Central Excise law. In the case of Now Bharat Fairwise, it is a tribunal judgment of 12/12/2006. Here in this case, now this certain goods were stored outside the factory on payment of duty. And this was done obviously because of the paucity of period. As you are aware of, under central excise law, no goods were permitted to be cleared outside the factory without payment of central excise duty. That's how they cleared on payment of duty. But at the same time, they filed a letter. That letter was dated 22/6/2001 and claimed that in an event of my payment of duty more than the correct sales price which I am making from the store outside the factory, I would claim refund. And clearance also started from that stored place from 22/6/2001. Then as they had sold at a price lesser than the price on which they had paid duty, central excise duty, that now Bharat claimed refund. Then refund was rejected on the ground that it has not been filed within 6 months. That time 6 months was there from the date of payment of duty. Then Honorable Tribunal held, they have written a letter, they have staked the claim, and that's why that letter dated 22/6/2001 would be treated as a letter of date for filing refund, and that's why it would not be barred by limitation. Yet another judgment of tribunal only in similar circumstances. You know, levy sugar was exempt or chargeable to lesser rate of duty on lesser value. And this sugar manufactured by a sugar factory, I am referring to UP State Sugar Corporation, that again stored outside, and the such sugar which was paid at on a normal value at a normal rate was sold as a levy sugar at lesser value and at lesser, that is concession rate of central excise duty, which give birth for claiming of refund. In this case also, they had informed to superintendent that I would be storing outside and take the claim. And in this case, as the refund claim was claimed, department as usual held that it is barred by limitation and you are not eligible for refund. Then Honorable Tribunal held the date of taking the claim is relevant, and that's why such refund claim would not be barred by limitation. Now I am going to the last judgment which we could find out, that is the Gujarat High Court judgment in the case of United Phosphorus. In the case of United Phosphorus, they paid duty on higher value on sale of goods which were stored in depot, and depot sales price was less, which was the law, that is duty was payable on the depot sales price, and they filed refund claim. Department returned that refund application for want of certain testing. And subsequently, when it was filed complete in all respects, that refund claim was held to be barred by limitation. In this scenario, Honorable Gujarat High Court held, first of all, there is no provision at all for returning such refund application. It should have been dealt with in the manner in which it has to be, and that's why it is not barred by limitation. Some of the judgments which give some way to say that although regular refund claim has to be filed in RFP 01, supported by evidence to the effect that on merits I am eligible for refund, I am virtually referring to subsection 4 of section 54, and incidence of tax has not been passed. Date of taking claim while interpreting central excise law has been held by tribunal as well as courts that it would be relevant for the purpose of computation of refund. Yeah. Now maybe in the sense these could be considered also. Now next slide, I think anything, I don't think anything is, yeah. Now big thank you. Before that, in the sense possibly somebody may be eager to question my all this thing. Yeah, please.
Patil sir, we would be taking a few questions people have posted.
Yeah,
So
yeah.
just please be with us for the time. Just give us 1 minute just to prepare, and then we can start. In the meantime, Rinav,
Yes, sir.
if you can start the questions, I'll join
Yes,
you.
sir.
I need to close this slide and bring him along. So you start the questions, please.
Okay, sir. Uh, Sir, firstly, thank you for such a deliberation today. Uh, we have queries flowing in the chat box. I would like to take the first query. Hello, Patil sir?
Yeah, yeah. Please. I'm hearing you.
Yes, sir.
Please.
Yes, sir. If a refund application for July 2017 due
Mhm.
to excess payment of IGST was applied for in the month of March 2020, can the officer deny the same, saying it's more than 2 years and refuse it? There is a press release dated 3rd July 2019 which says you may apply for refund if tax has been paid in excess. Will that press release come to our rescue?
According to me, that press release will not come to a rescue,
Okay.
because ultimately statutory provision of relevant period here, relevant date would be H, that is date of payment of tax. It doesn't fit into any of the exigencies specified in A to G,
Okay.
and that's why it would be barred by limitation under section 54(1), that is beyond 2 years.
And what if this refund was applied after declaring the correct turnover and liability in the annual return in January 2020?
Then possibly if he could have resorted to provisional assessment under section 60,
Hmm.
date of adjustment and finalization of provisional assessment under 60 would have come to the rescue.
Okay.
Since provisional assessment has not been resorted to, one has to fall back to the H only, that is date of payment of GST, and that's why it would be barred by limitation.
Okay. I have one more query.
Yeah.
A client is in line of preparation of mobile application on demand for his foreign clients.
Mm-hmm.
He develops the application and delivers it to them.
Mm-hmm.
He raises the invoice on one date and receives payment on another date.
Mm-hmm.
What would be considered the date of export or the effective service date?
Mm-hmm.
Especially in the present scenario when the services are completed, invoices are raised, and payments are not received. So, to calculate the time limit for difference, what would we consider the date of export?
That would be covered by clause C, which says that in case of services exported out of India,
Hmm.
where a refund of tax paid is available in respect of services themselves, or as the case may be so and so, receipt ours is covered by clause 1, receipt of payment in convertible foreign exchange,
Hmm.
where the supply of service had been completed prior to the receipt of such payment. Date of receipt of convertible foreign exchange would be the relevant date for the purpose of claiming of refund. Therefore,
Okay. Sheel bhai, can you take your queries? Hello, Sheel bhai.
Yeah.
Are you
It
ready with
says,
the?
yeah, I'm there. Patil
Okay.
sir, one question says, are the provisions of central excise service tax law similar to GST provisions? Whether it is specifically mentioned that it is to be in form RFD1, will the judgment of United Phosphorus be applicable to GST?
going by the provisions of law and going by Rule 90 of CGST rules, it would be appeal task to prove that the judgments under central excise would apply. But at some stage, in the sense on just and equity, possibly wherever one has taken the claim, I am referring to those three judgments of lower strength, this thing may apply. It would have persuasive support. But
Patil sir, request, can you be a little louder, sir?
if you ask me specific question that the judgments under central excise pertaining to limitation would apply, particularly date of taking the claim, I am of the opinion if those may not apply, will have only persuasive support. May not be up to, of course, GStat is yet to be formed, in the sense, again, GStat will comprise of the two technical members, central and state technical, and one judicial member, and majority will be technical only. Maybe at higher courts, things may change. Maybe they may consider. That is, date of taking the claim could be taken. And in that case, this judgment may come to a rescue. Yeah, please. Hello.
Yeah, Rinav, you can take.
Okay. Sir, we have another query is what is the relevant date for deemed export refund to be claimed by supplier to EOU? Section 54 14B says the date on which return relating to such deemed exports is furnished. So what is this return? Is it GSTR 1 or GSTR 3B?
It would be GSTR 3B return only, which supplier is making.
Okay.
And in case of recipient, see, so far as notification 48 of 2017 is concerned, and corresponding rules, either the recipient can claim refund, in which
Okay.
case date of receipt of goods would be relevant for the purpose of computation of 2 years. And in case the refund is claimed by the supplier, then date of filing of return showing the supply of these goods would come into the picture.
So that is GSTR 3B.
Yeah. I'm referring to G.
Okay.
In this case, yeah. Other than supplier. Yeah.
Okay.
Okay.
Sheel bhai.
Yeah, I'll take one. It says, at the time of GSTR 9 and 9C, the registered person comes to know about an excess payment made by him during financial year 17-18. However, the time limit of the 2 years from the date of payment has already been expired. So the question here says, is there any safeguard available to the registered person in this form, in this case?
Only safeguard will be taking a route of provisional assessment under section 60 of CGST Act. If he has not taken, then the 9-judge bench judgment of the Honorable Supreme Court judgment in the case of Mapatlal would apply here. Refund under all circumstances are subject to limitation, except where the levy has been held to be unconstitutional. I don't think there is any way. Only provisional assessment under section 60 of CGST Act.
Right, sir. The another one says, if a dealer comes to know of a situation where he has taken credit in incorrect head, which has come to his notice during the GST audit, which may be after 2 years from filing the original return in 3B, payment is made in correct head during the audit in the DRC 03. So the limitation of 2 years apply from making the payment of DRC 03 during the GST audit, since taking the credit, since taking the credit in correct head also lapsed, and the expect refund no option, and accept refund no option is available to the dealer. What should be done, sir?
Are you referring to dispute and place of supply?
No, sir. No, sir. Not place of supply, sir. It says the dealer comes to know of a situation where he has taken credit in incorrect head, which has come to his notice during GST audit, which may be after 2 years from filing the original return in GSTR 3B. Now, payment is made in the correct head during the audit. So the limitation of 2 years from making payment has already been elapsed. So except refund, no option is available to the dealer, or is there any other option available?
But why refund has to be claimed here?
Right, sir. I think there is some error in the query.
Because if he has taken under wrong head, it can be corrected. And it is not a case that he has not satisfied any of the conditions 4 in number specified in section 16(2). He has satisfied all the conditions. Instead of accounting in this head, he has accounted in another head. I don't think it can be denied. Or rather, for denying limitation also would come into the picture.
Okay, sir. Okay.
Yeah, please.
Now, Rinav, you can take one.
Okay.
I think,
sir,
since the time is up, we will take this question as the last one, and then we'll try to end the session. Right, sir?
Okay. For me, no problem. Yeah.
Yeah, Rinav, take this last question.
Yes, sir. In case of inverted duty structure, the relevant date earlier was the end of the financial year. But with effect from 1st February 2019, it has been changed to 2 years from the due date of furnishing of return. So what will be the due date of filing refund for the periods prior to 1st February 2019? Will it change for all the cases which are yet to be filed?
First of all, I appreciate the person who has raised this question.
Okay.
Whosoever he is there. I really appreciate him. As you rightly analyzed, Subsection 3 of section 54 covers two exigencies of refund of unutilized credit. One, making zero rated supplies under bond or LET. Two, rate of tax on inputs higher than the rate of tax on outputs, that is inverted tax structure. Till 1/2/2019, prior to substitution of that clause, I think you are referring to that particular clause E, it covered both. While from 1/2/2019, they have restricted only to inverted tax structure, that is clause 2 to first proviso to subsection 3 of section 54. And that time up to 1/2/2019, refund could have been claimed within 2 years from the end of the financial year. From 31st March, say 2017-18, if you take, from 31st March 2018, he could have gone up to 2 years, 20. As against that, from 1/2/2019, it has been restricted to the return due date of furnishing return under section 39. Then on that 1/2/2019, the period of limitation for claiming refund has been reduced by 11 months. As per the law on the issue, the law prevalent on the date of claiming refund would apply. Here I would like not to stop here. From my memory, I'll take some judgments.
Yes.
There was a judgment of Honorable Bombay High Court in the case of New Bombay Party, Uttam Steel, wherein you remember section 11B, refund claim up to 12/5/2000 was to have been filed within 6 months from the relevant date. That 6 months was enhanced to 1 year from 12/5/2000. Then on 12/5/2000, there were many refund claims which were beyond 6 months but within 1 year. Whether would be barred by limitation. Then Honorable Bombay High Court, still I remember, Justice Daga and Justice Devdas Saab, and they held that this limitation is only a procedural and it cannot be considered as substantial. And that's why change of limitation from 6 months to 1 year would have retrospective effect. Benefit flew to trade. This judgment of the Honorable Bombay High Court in the case of Uttam Steel was challenged by the department. My friend has taken out the judgment before Honorable Supreme Court. Honorable Supreme Court, comprising of Justice A.K. Sikri and Justice Rohinton Salinarman, set aside that judgment and held in a different way. They held, I'll take, since my friend Mr. Sachin has taken out the judgment, I'll take some dates also from that. In that case, goods were supplied in May 25/5/1999 and 10/6/1999. And refund claim was filed on 28/12/1999. It relates to export of goods beyond 6 months as on 12/5/2000. Then Honorable Supreme Court held on 12/5/2000, 6 months had already expired. 25/5/1999 and 10/6/1999 are the dates on which shipping of goods had taken place, and a refund claim has been filed on 28/12/1999 beyond 6 months, and amendment has taken place on 12/5/2000, that is from 6 months to 1 year, and that's why as on 12/5/2000 it was dead horse, dead claim, and this dead claim cannot be injected to revive the life. In that context, Honorable Supreme Court, while reversing the High Court judgment, held that new of limitation providing longer period cannot survive and would not be applicable. Invoking the ratio of the said judgment to our case also, if any of the refund claims have already been filed within the stipulated period of time prior to 1/2/2019, would be, that is within 2 years from the end of the financial year, would be valid. And if any refund claims have been filed After 1/2/2019, curtailment of 11 months would come into the picture. Relevant date will go back to due date for filing return under section 39. And that's why would, according to me, invoking this ratio of Supreme Court barred by litigation. Yeah, please.
Okay, Sheel bhai, I think.
No, if any questions, if any urgency is there, you can put questions, and no problem. I
Okay,
don't
sir,
have any problem.
I think all questions have been taken, and we'll end the situation and end it over here. Sir, for the formal vote of thanks, I would like to invite Yatish to introduce, to give the vote of thanks. And my sincere apologies to all the members present and for the disturbance in the sound. But, you know, as we all know that some things in life are not controllable at our end. We tried to manage it to the best of our ability, and the entire team was after it. So please excuse us this time. We'll take care of it in future. And thanks for the comments in spite of that. And bigger thanks for staying with us for so long. Yatish, please take over and propose the formal vote of thanks.
A big thank you to M H Patil sir on a Sunday morning like this, in spite of lockdown also, and on a weekend, he agreed to come and take this session on this very niche theme, time-bearing refunds and important judgments. I think in spite of the technical issues which we faced, I think sir has really done a superb presentation on this specific theme. And I think the plethora of judgments which he has given, I think will definitely be an asset to the data bank of our listeners and viewers. I'm sure because of these technical issues, a lot of our members would like to probably listen to this presentation again, and that will be available to them. And once again, a big thank you to sir for his efforts, and thank you to the audience for being patient with us till the end. I'm sure there were a lot of issues in between which we faced, but yet they stayed on, and I think that shows the kind of commitment they have for learning. That inspires the team CGPI, you know, to try and improve and make sure we keep coming up with better and improve on wherever we have probably not made it well this time. Thank you, sir. Again, thank you all.
Yeah, thank you very much. Thanks a lot. Thanks everybody.
Thank you, sir.
Yeah, please.
Thank you, sir. Thank you so much.
Thank you very much. Thanks a lot. Oh.
We can end it, Yatish bhai.
Stop, na?
End for all.
End for all.
Fine.
Live.
उनका प्रॉब्लम है उसका प्लीज भाई एंड कर दो, एंड फॉर ऑल कर दो
उसके सब ये हो रहा है ना जूम का, लाइक आपके यहाँ पे अगर ये नहीं रहेगा
रिकॉर्डिंग तो स्टॉप हो गया, एंड फॉर ऑल कर दो।
End for all करना है यतीश भाई।
हाँ,
यहाँ पे बटन स्टॉप
At the bottom right.
क्रॉस करोगे तो
Bottom
आपको
right.
ऑप्शन मिलेगा।
Bottom right, bottom right.